Please take your seats.
Good morning. You can call the case, Mr. Hadia.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, CCJ Appeal number 5 of 2018, between Octavius and Laurent John versus CLICO International Life Insurance Limited. For judgment this morning. Can we have the appearances for the court, please? Thank you.
Ramon Aline with Sheena Ann Inks of Clark Dickens Pharma on behalf of the respondent.
Your Honors, Zaida J.
Go ahead.
Your Honors, good morning. I'm Zaida James, appearing with Kevin Miller, attorney at law.
Thank you very much. The judgment will be delivered by Justice Hayton in a summarized form.
This is the unanimous judgment of the court. The President, Mr. Justice Saunders, and Madam Justice Rajnath Lee not being available this morning, but having signed the judgment along with the rest of us. And I shall read out a judgment summary, but one must remember, of course, this summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. The full judgment is what must be had, what recourse must be had to. But in summary, the appellants, Octavius John and Laurent John, the John brothers, invested in several executive premium annuity policies with the respondent, CLICO International Life Insurance Limited, CLICO, a Barbadian company in the business of general and life insurance, investment annuities, and other investment programs. At the expiration of these policies, however, CLICO did not pay the John brothers their entitlements, intended by them to be relied upon for their retirement needs, having retired to Dominica after working in New York, and one brother with prostate cancer having expensive medical costs. After much prevarication from CLICO, the John brothers were driven to take legal proceedings to recover the money due to them, so that on 7 September 2010, they obtained default judgment against CLICO in the High Court of Dominica in the sum of $1,423,329 EC dollars and 46 cents plus interest. After further stalling for time by CLICO, the John brothers obtained a court consent order on the 4th of February 2011, by which CLICO undertook to pay to the brothers $775,000 EC dollars a month, commencing 30th of April 2011 and continuing until final satisfaction of the said judgment. CLICO also undertook to pay costs and interest pursuant to the judgment. However, as a result of proceedings brought on the 14th of April 2011, CLICO was placed under judicial management pursuant to the Insurance Act of Barbados, and no payment was made to the John brothers. The John brothers therefore sought to enforce their Dominican judgment debt against CLICO by converting it into a judgment debt in the High Court of Barbados. Pursuant to Section 57, subsection 4 of the Insurance Act, all actions and the execution of all writs, summonses, and other processes against CLICO were stayed and could not proceed without the leave of the court being first obtained, or unless the court otherwise directs. The John brothers therefore filed an application seeking leave from the Barbadian High Court to be at liberty to begin proceedings against CLICO to recover the amount due under the Dominican judgment. The application was heard by Cornelius J., who granted the application, paving the way for the matter to proceed to case management. CLICO, however, appealed to the Court of Appeal, which allowed the appeal on the basis that Cornelius J. had failed to provide reasons for her decision to grant leave to the John brothers to commence proceedings. The Court of Appeal, having the documentary evidence before it, in the interest of saving time and expense and with the aid of extensive submissions on case law concerned with leave to enforce claims, considered it fit to determine the application itself, treating the application as covering both leave to commence a claim and leave to enforce it. After considering relevant case law, the Court of Appeal refused leave to the John brothers to enforce their claim. In the Court's opinion, given the financial difficulties of CLICO and the extent of its business throughout the Caribbean, it was reasonable to assume there were thousands of policyholders who were similarly prejudiced because they were unable to recover their monies. If leave were to be granted to the John brothers, one, they would be able to cover all their monies in priority to the other policyholders who had to wait until the judicial manager's proposed restructuring plan was approved by the court and satisfactorily implemented. Two, CLICO's assets would be diminished to the disadvantage of the remaining policyholders. And three, there was a likelihood that other policyholders would make similar applications. Further, the John brothers had not established that their claim was unlikely to be addressed by the proposed plan. The Court of Appeal granted the John brothers leave as of right to appeal to the CCJ without any objection from CLICO. Before the CCJ, CLICO filed an application to strike out the appeal long after the John brothers had filed their notice to appeal pursuant to a certificate of compliance given by the Court of Appeal. CLICO submitted that the court had no jurisdiction to hear the appeal on the basis that the Court of Appeal had erred in allowing the John brothers to appeal as of right to the CCJ. This was because, in CLICO's opinion, the Court of Appeal's decision was an interlocutory decision and could only be appealed by special leave from the CCJ. There were, therefore, two issues for the CCJ's consideration. One, whether the court had jurisdiction to hear the appeal, and two, whether leave should be granted to the John brothers to enforce the Dominican judgment debt and CLICO directed to pay it. The CCJ noted that normally a foreign judgment creditor should first seek leave to bring summary proceedings for the amount of the judgment debt to become an enforceable local judgment debt. Leave should then be sought to enforce the judgment. However, the court opined that Section 57, subsection 4 was broad enough to cover one leave application for both proceedings, and that this latter approach was appropriate in the special circumstances of this case, where there was a clear debt accepted by CLICO in agreeing to a court consent order for monthly payments in satisfaction of a judgment debt, and not disputed by them in the current proceedings. This also appeared to be the unarticulated assumption upon which the decision of the Court of Appeal was based. Thus, if leave were granted, the court was in a position to give a final judgment for the amount of the debt, while if leave were refused, that would finally determine the proceedings. In these circumstances, the court found that these proceedings were final and not interlocutory, and therefore the Court of Appeal had not erred in granting leave as a right. The CCJ, however, added that even if the proceedings had been interlocutory, it would have exercised its power to grant special leave under Section 8 of the Caribbean Court of Justice Act, the John brothers having been innocently misled by the Court of Appeal and CLICO until CLICO's strike-out application late in the day. The court agreed with the Court of Appeal that judicial management was aimed at restoring, for the benefit of policyholders, the financial well-being of an insurance company over a reasonably short period to avoid, if possible, the company being placed in liquidation. This was done by the judicial manager's proper management or proper conservation of its resources. The court noted, however, that a judicial manager has more flexible powers than that of a liquidator or trustee in bankruptcy dealing with an insolvent company under strict statutory priority rules. Under Section 59, subsections 5 and 6 of the Insurance Act, the court could issue directions to the judicial manager as to his powers and duties, as it seems desirable in the circumstances of the case, and the judicial manager was required to act under the control of the court. Section 61, subsection 1 of the Act, as well as an order of the Barbados High Court dated 29th April 2011, also conferred extensive powers upon CLICO's judicial manager, including the power to process claims against the company, to pay any class of creditor, and any claims, settlements, and expenses in part or in full, and to rank, manage, adjust, and pay claims against the company and or its policyholders. The court also agreed with the Court of Appeal that the prohibition on the commencement or pursuit of proceedings against the troubled company was critical to the process of judicial management. In order to enforce their monetary claim against CLICO, the starting point for the John brothers was for them to show, as held by the Court of Appeal, that one, they would suffer exceptional prejudice by the continuance of the stay. 2, such loss would outweigh the potential consequences to other policyholders if leave were to be granted. And 3, their claim was unlikely to be addressed by the judicial manager's proposed scheme or arrangement. Account also needed to be taken of the flexibility afforded to the court by Section 59, subsection 5 and 6 of the Insurance Act. The court was satisfied that the John brothers had made out an almost certainly unique case for leave to be granted. Of significant weight to the court's ruling was that 1, the brothers were vigilant enough to do all they could to extract their money from CLICO before a realistic possibility of its collapse happened. 2, they obtained judgment in their favour and a court consent order for CLICO to make monthly payments satisfying the amount of the judgment debt. 3, CLICO's actions, of course, encouraged the brothers not to take steps to obtain a charging order over CLICO's property or a garnishing order over CLICO's income. 4, CLICO does not dispute the validity of the brothers' claims established under the Dominican judgment debt. And 5, the brothers, who had actively done all they could to protect their interests, now find this is counted against them, making themselves worse off than the passive policyholders. This is because the judicial manager conceded in the hearing before the CCJ that it no longer ranked them as policyholders, having exchanged their policies for a judgment debt, but as mere ordinary unsecured creditors for whom no provision had been made under the plans of the judicial manager, so that their claims would not be addressed. Furthermore, the court emphasized how significantly handicapped it had been by the judicial manager's lack of evidence before the court hearing below as to the progress of the judicial management, while acknowledging it was self-evident from the excessive length of the judicial management over the last 8 years that there must be significant financial deficiencies remaining to be addressed. The court was of the opinion that in these adversarial proceedings, in balancing the exceptional prejudice suffered by the brothers against potential consequences to other policyholders, the brothers satisfied the evidential burden of raising a prima facie favourable case, so that the evidential burden passed to the judicial manager on CLICO's behalf to upset that case. This burden had not been discharged in the absence of evidence as to CLICO's current position under the judicial management. In the unique circumstances of this case, the court felt obliged to resolve the issue between the parties without wasting time and costs in further proceedings. The court therefore directed the judicial manager to recognize and pay the debt of $1,423,329 EC dollars and 46 cents to the John brothers within 10 days of the court's judgment, after which interest shall run at the judgment rate applicable in Barbados. Having regard to Section 59, subsections 5 and 6 of the Insurance Act, the court did not consider itself in a position to direct that any interest be payable before such 10 days. Claims to capital need to be satisfied before claims to interest. No order as to costs was made, just as no order as to costs was made in the court below when the brothers lost their claim.
Thank you. Is there anything that at this point?
I'm sorry, I didn't.
Ms. James, is there anything?
Yes, sir?
Is there anything you need to say at this point? Or-
Yes, Your Honor. First of all, I would like to thank, I don't think the John brothers would find the words to be able to thank the court for its decision this morning, so we're very grateful. I do need some clarification, and that's perhaps just me not being fully comprised of all the law with respect to security for costs. I suppose there's a procedure for recovering that because the John brothers did pay in some amount for security for costs. Is that something that's procedural where we will address the registry for that with respect to recovering those sums? Because they would have deposited $10,000 as security for costs.
Okay,
I don't
well-
know if your honors are aware.
Yeah. So that can be dealt with in the court order.
Procedurally, yes. Oh, in the court order, okay. And just with respect to the interest, we understand the court's interest and costs. We understand the court's in this, with respect to the costs. With respect to the interest, we know, we are aware, as could have been said in the judgment here, that interest was awarded in the Dominican courts. But this court doesn't feel essential to apply that interest either.
It's what you can enforce. And what you can enforce is that amount that is mentioned, and under this procedure you cannot enforce that part of the interest.
Right. So the interest is with respect to the proceedings in Barbados going forward. So if the court
Which
barring
means
us
that it is still owed, but you cannot enforce that part.
You can't get interest way back from 2010. All you can do is get interest from 10 days after payment of the debt that we've directed today.
Yes, I understand that. And so the interest from the judgment in 2010 that was awarded, that is up until the judicial management at least. Is that something that's enforceable somewhere else or not at all? Or how does the court see that? Just for clarification.
You're not allowed to enforce it at the moment. If in fact things develop wonderfully well, it may be that the judicial manager may be able to pay interest. But currently, you're just entitled to get your capital back, and you're fortunate to be in that position.
Yes, we are fortunate and we're grateful. Thank you, sir.
Good. Mr. Alim?
No, my lord, your decision is understood. We have no further comment.
Okay, thank you very much.
Court rise.